We're not going to record with one, it's got new dates, Greenwood.
Oh, I know.
Time picture on the 15th. Greenwood.
Last one.
No, because there's a bench wire right now. Oh my. Final picture on the 15th. Both the attorneys are here for this one, Judge.
Which one?
The very first one on the afternoon. Carmichael and Terry Norwood. You guys, right here.
What about Wormish?
They didn't, they got a new date on it, I don't know what that was. That's another way to.
This is docket 256250 NM. And this is Carmichael versus Bailey and Terranova. Counsel, your appearances for the record.
Good morning, Your Honor. James Hunter on behalf of the defendants.
Ralph Carmichael on behalf of the plaintiff.
Thank you. And this is defendant's motion.
Yes, Your Honor. May I approach the podium or would you like me to address them?
Yeah, you two are switched, but yes, at the podium is fine.
Thank you, Your Honor. This is defendant's motion for summary disposition, filed in lieu of an answer in this case. This case was styled as various claims by a former client against their lawyers from an underlying divorce proceeding. The complaint runs the gamut, claims of.
I'm sorry,
I apologize.
no, the door got me. Various claims by a former client against their
Attorneys, their
Okay.
lawyers, arising from an underlying divorce matter. The claims run the gamut from general negligence claims to fraud, civil RICO, intentional infliction of emotional distress. Our arguments are twofold. The first part, Your Honor, is essentially that this is, despite the labels, a legal malpractice case, and only a legal malpractice case. We have addressed each of the claims in detail and why they fall under the umbrella of a legal malpractice claim only. I'm happy to answer any of Your Honor's questions about any of those particular counts and why they fit the mold of a legal malpractice case, if Your Honor would like. But that is the first part. Now, the fact that this is all under the rubric of a malpractice claim and nothing else, we argue that the claim should be dismissed on various grounds. First, Your Honor, in a legal malpractice case, one of the elements is proximate cause. This falls under what I style as a settle and sue type case, where a client settles a case, in this case, through a consent judgment of divorce, a divorce settlement. It appears to be unhappy with the results of that settlement and then sues their lawyer. In such a case, those are hard hills to climb. And generally, there are circumstances in which they are viable claims, but this is not one of them. It's not one of them because one of the elements or the factors the court had to consider is whether or not the client was forced to settle rather than going to trial. For example, in some cases, if a lawyer abandons their client on the eve of trial. Second, and we don't get into this too much, is that they have to prove that they would have had a better outcome but for the alleged malpractice. So here, in this case, it looks like generally the claims are that he was forced to settle because he claims his lawyer backed out. And second, that the terms were unfair. Neither of those are true because what we have is the actual settlement of the divorce, as well as a transcript from the divorce settlement hearing in which the underlying court confirmed with Mr. Carmichael under oath during voir dire that he was satisfied with the terms of the settlement, that the terms were fair, and that he wanted to settle. The second issue is Mr. Carmichael appears to allege that he had to go to trial immediately. He had no lawyer, so he had to settle. Again, that's not true. We have a hearing transcript from November 4th in which Mr. Carmichael, it was actually a motion to withdraw by the former lawyer, my client, and the court asked Mr. Carmichael, would you like additional time? We'll hold everything off, or do you want to move forward? At that time, actually, even before the ink dried on a withdrawal order, Mr. Carmichael advised the court that he had already settled the case. So he was fine not adjourning anything. He wanted to move forward. And several days later, they appeared again and put the settlement on the record. So for the proximate cause issue, he cannot prove that he was forced to settle. It was voluntary. He testified it was fair. The judgment of divorce itself says it was fair. And the second part, Your Honor, is an estoppel argument. In this case, we can apply estoppel despite a lack of identity between the parties in the legal malpractice case versus the underlying case. It's a bit of a carve out under the law for legal malpractice cases, particularly, where a party cannot assert, in this case, something contrary to what was asserted in a prior proceeding. Here, Mr. Carmichael, we argue, is precluded from arguing that the settlement was unfair or not voluntarily entered because he testified under oath that he was voluntarily entering the settlement and that it was fair. There's a lot of other claims mixed in there. A lot of them, Your Honor, appear to be general unhappiness with the representation, claims about, maybe the fees paid. Those, Your Honor, in my view and as set forth in our motion, appear to be arguments related to the rules of professional conduct, which by themselves do not make for a case of negligence. So if Your Honor does have any questions about why we believe this does fall under that umbrella of legal malpractice claim, I'm happy to address those.
Thank you.
Thank you.
Response?
Good afternoon, Your Honor. This case has a lot more to do than just malpractice. Okay? And also, it's about a lawyer and a lawyer's conduct, which is completely reprehensible. It's about unlawful billing practices. It's about, and not relevant to a divorce. Okay, she did not do, Michigan recently, a couple of years ago, recognized that you could have limited scope representation. She specifically did not do that. It is not limited to divorce. So the argument that the defendant is making that this is just merely a divorce case is false. It's just wrong. It is about a lot more than just divorce and the divorce case. It's about her taking on a client where she knew she was incompetent, not doing any work that she was required to do or should have done, and also billing for her time when in fact her paralegal did the work or I did the work. So she overbilled. She sent those through the mail, which is a federal crime, and she sent them via email. She completely mishandled the case as an understatement. No discovery, no filing. But she knew on the day that I met with her, and this is pled in specificity, the date, the time, and when she did.
You're not only the plaintiff, but you're also counsel.
Yes.
Okay, I got you. Okay, I was.
So she, I'm sorry, were you finished?
Well, so understanding all of that, I've read the transcript of the divorce, and it appears that you still were happy and wanted to proceed, and you're a lawyer. No. Okay, so but you didn't tell the judge that, did you? At
the time that occurred, okay, first she withdrew a week before the trial. She had depleted, and she knew this, all of my cash resources. There's no way that I could have afforded a lawyer. There's no way I could have gotten counsel in time. There's no way I could have gotten counsel up to speed. She had left me in a situation where I would be prohibited to proceed with the commercial portion of my issues. Okay, when the parties, in this case it was a divorce, but all of my other legal claims would have been precluded. That included the unlawful lockout that she did that was admitted in court by them. That includes a embezzlement. That includes all my commercial claims, which On the first day I met with Ms. Daly, I outlined that this is a commercial case about commercial matters, yet she took me on as a client when she knew she wasn't competent. Now, later on, she admitted I'm not competent, and she also said to me, I will not do the commercial work. As a result, by the time we got to that point, all the foundation of the case was laid. There had been no discovery. We hadn't gotten any corporate documents back. There were multiple violations of court orders. She didn't do anything, yet she billed like I was suing the federal government or something. I mean, she overbilled. She billed $22,000 and she did almost an hour's worth of work. So she overbilled. So this is about the billing. It's about the billing practices. There are multiple issues of fact. And when you take the complaint in the best light for me, we've pled everything in specificity. There are multiple issues of fact that need to be determined in terms of this, including proximate cause, which the Court of Appeals has said is an issue of fact. And sometimes they say it's an issue of law, but it is an issue of fact in this case. So she acted, and it's kind of interesting. When I was talking to one of my colleagues about this, he said, you sued the matriarch. She is so well known in this community as the matriarch of divorce law. And she's out there taking on clients that she knows she can't represent. She knows she doesn't have the capacity, the legal capacity, or the competence to do it. That's the fraud. She defrauded me. She left me hanging. I had no choice at the time of that settlement but to take whatever they shoved down my throat. I didn't have time to prepare. I would have needed she had about 6 months to prepare. She could have filed the commercial suits. She could have filed on the unlawful lockout. She could have done the work in order to prepare it for the trial. She didn't. She didn't do any discovery. She didn't even get my documents back, which meant that she ran a mediation, which I told her was a waste of time and money, and she did it anyway, and it cost money. She depleted all of my cash. At this point, I'm destitute. I have no money. I can't pay my rent. I'm almost homeless, and I have no money. She never brought that to the attention of the court. She let the court believe that we were rich, and she let my cash resources get depleted. She did all of this. So at the end of the day, this is not about whether the judgment was fair. I had no choice. It had to be taken at that point. There was no foundation. There was no way we could go to trial at that point. We had a week, and the judge said, oh, I'll give you an extension of 30 days. 30 days was not enough and to do what needed to get done in order to prepare for that particular trial. So I was put in a position at that time. So under the judicial estoppel argument, where they're arguing, well, I said it was fair. No, the judicial estoppel, as the Michigan courts recognize it, say that it has to be part of the judgment. In this case, the final judgment of divorce says nothing about, she never opined on whether it was equitable or fair. She just accepted it. She opined on whether the marriage had broken down, which again, since we're planning on getting remarried at the moment, that's kind of an issue too. But at the end of the day.
Well, sir, wait a minute. At the end of the day, and I have the transcript here, I think the judge said, oh, and this is on page 21 by the court. Okay, and from your standpoint, there's no possibility that this marriage can be preserved. Is that correct? And your answer was this marriage, no.
At the time that was happening, we were still litigating. We are now actually planning on getting married.
Okay, so that has no bearing on.
No, it has no bearing on this,
okay.
On this case,
okay.
Good point. But at the end of the day, I didn't misrepresent anything to the court. I had no choice at that point. The lawyer did no work, but this case is not just about the divorce. It's about the way she operated and the way she sucked me in to suck my money dry. She lied. I relied on her lies. She has a big reputation. She's a member of Adam. She has all these different kudos, and in her agreement with me, she says she's going to use competent attorneys. That was false. So this case is as much about the contract as it is about this, and it really is about justice. Do we allow lawyers to do this?
That's why we have the state bar agreements. Here's something else, sir. Explain this to me. And do you understand that after today, neither party can come back? I forgot one thing. Neither party can come back and say, I was under duress or I was under the influence and I want to set the agreement aside that was made today. Do you understand that? I understand. I mean, the judge went through all these things and you kept agreeing, and you're a lawyer. Why did you agree?
Okay, one, I had no choice.
You had a choice, sir. You're a lawyer.
I could have, okay, had I said, no, it's unfair, whatever, what was I gonna do?
It would be set for trial. You can ask for an extension. You could have told the judge, I need to fire my lawyer. There's lots of things. I don't need to go through the whole 100.
No, I understand there are things, but at that point, I didn't have the money to pay a lawyer. I'm not competent in matrimonial law. And also, my ex is an alcoholic and was under the influence when she gave that same testimony. So, and also that was done after the fact. In other words, you shouldn't even be reading it because it's after the engagement ended. We're dealing with an engagement with a lawyer that ended. That testimony you're reading comes in after the fact. It's highly prejudicial. It should never be admitted. And I did put that in motion. So I had no choice at that point to say whatever. I had absolutely no choice. If I had gone to trial, I would have had to hire a lawyer. Didn't have the money for the retainer already checked. I couldn't file the various suits that needed to have been filed. I was already precluded from them. I couldn't, the discovery that needed to get done. There wasn't time for it. The judge wasn't going to give that much time. We had already taken as many extensions as we could. We had already put it out as far as we could. That divorce case was about a private company that's fairly valuable, that we still haven't been able to sell as a result of that settlement. So they basically laid no foundation for me to go to trial. I couldn't go to trial. I had no choice. I had to say whatever I had to say in order to get that done. And worse than that, she knew it. Because she said something to that extent to me literally hours before she withdrew, when she tried to extort money out of me. She told me to sell a car, to borrow money, but in order for me to go to trial, I would have to give her $25,000 after I had already paid her an extreme amount of money.
So you got the divorce, you wanted the divorce, you were the plaintiff. Forget about.
No, I wasn't. I was the defendant.
I'm sorry. Okay, you were the defendant. But you went through with it, and whatever's happening now, I don't really care about. But is your main complaint the commercial litigation?
Yes.
So malpractice as the commercial litigation that she took on and mishandled that became part of the divorce.
Yes.
What about the other parts of the divorce?
What, you mean the settlement and?
Yeah, personal, whatever, retirement accounts, all that was done.
Where everything that we had, the only assets that we had were the company, the factory, and the commercial stuff.
Okay.
And one house.
Okay, was there, I mean, I don't have all the divorce documents, so
Right.
just let me ask you a couple of questions.
Yeah.
So in regard to this business, was there a business valuation? Was that done so that you could negotiate that in mediation or not?
No,
Why not? Do you know? Was that something where she said, I need to do a business valuation, and you said, I can't afford that, or don't do it, or here's a value we've agreed to, or anything like that?
no, none of that happened. There should have been a valuation on the company. We were trying to sell it. The divorce destroyed that, as well as the fact that my ex is an alcoholic, and she locked me out of the business for about a month, which destroyed the company.
Okay, who was running the company at that point? You or her?
Me.
Okay,
I owned 100% of it. Another thing that my lawyer refused to take care of. And I owned it before the marriage. So it was premarital property.
and there was no evaluation about pre and post?
It would have been irrelevant because the property, the ownership of the company, 100% of it was owned by me prior to the marriage.
But you brought it, did she, okay, I don't want to read through this whole divorce, but let me ask you a
Neither do
couple
I.
questions. Did your ex-wife, now fiance, work for the company?
Yes.
Or, okay, did she get compensated as an employee or not compensated because she was a spouse?
Not compensated because she was a spouse.
Okay, so there's your problem, but there should have been a valuation up to the date of marriage, and then the date of marriage forward should have been a valuation, and then you each get half or whatever, because you brought her in and you acted, you sort of, anyways, I'm not the divorce attorney, but I did divorce.
She
for
did
20
get,
years.
she
So-
didn't get a salary, but she did get money.
Okay, so before the marriage and after the marriage, there's no evaluation.
Mhm.
What happens to it in the judgment
The judgment split 50-50
for the whole time?
for the whole company, a company I started before I met her.
Were there any post-nuptial agreements in regard to the company?
No, 30 years the company was in existence. She was with it for about 10, maybe 5.
Okay. So primarily, the malpractice claim would come not on the divorce specifically, but as it relates to any portions of the company, the being locked out, the valuation or lack thereof, and that it's then negotiated blindly, so to speak, in the divorce. Is that right?
Not exactly.
Okay, what did I miss?
What should have been done was the proof of the company being a premarital asset.
That comes in the valuation, because pre would be from it would be yours sole and separate until the date of marriage. Once there's marriage and once she puts some sweat equity, then we got a whole different ballgame there, sir. So there's pre-marriage and then there's post-marriage.
Right.
So there's 2 valuations. So I got it.
Right.
So what else is your complaint?
My complaint is the degradation of value that was caused by the commercial issues. In other words, she locks me out. She doesn't know what she's doing. The company has not got up and going again. It makes spine implants, so it's highly
I'm sorry,
regulated,
the company is not,
up and operational. And the company makes spine implants, so it's a very complicated business.
Okay.
She got us in trouble with regulators.
When you say she, are you referring to Ms. Bailey?
No, my ex.
Your ex?
Okay, my ex locks me out. That lockout was unlawful. Her lawyer admitted it was unlawful. He said, oh, well, ignorance of the law is no excuse. That lockout extended for over a month. During that month, she destroyed the company.
Okay, was there any status quo? Usually when you file a divorce, there's also a status quo of assets, so they run how they are, so this doesn't happen. Was that order in place by the court? Do you understand?
There was a status quo order in place. My lawyer never enforced it, and also she never filled out her financial filing until a day before the mediation, which was like a week before the withdrawal.
Okay, anything else you want me to know?
Not really.
Okay, thank you. Council response?
Thank you, Your Honor.
You know, come on up, they're divorced, so her job in regard to the divorce, I get that. But how does she take on commercial litigation? Explain this to me. How does she take on a commercial portion of a property settlement where there's no valuation and there's no adherence to the status quo so that this does not happen? Can you answer that? And I don't want to relitigate the divorce, but I understand why he's unhappy now. It's not really the divorce, despite the relationship today, it's this commercial side of it. So can you just go there?
Yeah, she didn't
She didn't what?
undertake that representation at all. The engagement agreement is attached to our response is very clearly the divorce proceeding. That is the scope of the representation. Now I think I understand more Mr. Carmichael's argument about the limited appearance argument. I'll be frank, I did not understand it in the briefing phase.
Okay, well, and that's why I asked so many questions.
Yes.
Thankfully, I had done 20 years of divorce work, so
Okay.
I understand this, but let me just
Sure.
ask you this. Once she takes on the divorce and both parties have a claim to a business, regardless of what kind of business it is, there would be the pre-valuation and the post, and it appears that was not done.
Your Honor, if I'm very hesitant to get into.
Because I'm hesitant
Facts.
to grant your motion, although initially thinking, yep, it's all right here, because I don't know if this goes back to the family court judge to reopen this based on some kind of misrepresentation or fraud or what have you, to end up with a valuation of a company, or it comes to me for something else, because this is an asset of the marriage. The case law is that you are supposed to preserve all assets of the marriage, the credit, et cetera, et cetera. And if this was the way he sees it, I'm not saying it is, then that flies in the face of the case law, which is why we have the standard clauses about, we're gonna run the marriage how we have been until it's decided at the end, right? So we don't lose credit and other things that are assets, and this business was an asset. So where do we go from here?
I'm gonna work backwards,
Okay,
Your Honor. This is why the case law is so clear and succinct. Parties are free to settle cases however they want. There are a variety of reasons a party may choose to settle rather than go through the expense of discovery. In this case, I do not want to cast aspersions on fellow counsel. However, again, I just don't want to get into the questions of fact, because it's not a question of fact. My client was hamstrung in her ability to represent Mr. Carmichael because of his desire not to engage in certain discovery because of costs. I have emails that would show that, but again, we don't need to go there because the property settlement included the business. Under oath, Mr. Carmichael agreed this is what he wanted to do and that it was fair. This is why that case law is out there. It precludes second guessing. It includes essentially buyer's remorse, which is what we have here. The property, and I think it's in the transcript on page 18 where it says, let me verify that. It says all material terms of the divorce and everything you want is included here. It's in that transcript. And this is why, Your Honor, because lawyers should not have to be in a situation when a client decides to settle instead of going through the expense of discovery and trial. That's what we have here. I didn't attach those emails because I don't think it's necessary in order to rule on this motion, because we have a voluntary settlement that incorporates all of the marital assets, including the business that was voluntarily entered into. There are a lot of reasons why folks don't want to spend. I mean, Mr. Carmichael is complaining about a $20,000 legal bill right now. A property valuation or a business valuation could certainly exceed that. If you look at his pleading, it says that the company is, in his mind, worth $6 million. A valuation of a business like that is going to cost $20,000 potentially, right? There's a lot of reasons why folks decide to settle in lieu of trial, in lieu of expensive discovery, expensive experts in contesting issues like that. That is what occurred here, and the case law says you can't second guess that.
Well, what was, understanding that, what was the settlement in regard to the business? What happened?
I believe it's an appendix I believe it's 50-50 according to Mr. Carmichael. I don't have it earmarked right now, Your Honor, but I believe there's an appendix for the consent judgment of divorce. It is attached as exhibit G to our motion, that discusses, essentially, it looks like almost like a status quo regarding the business itself and the handling of the business, but I'm not sure where it's
But
earmarked.
wouldn't it be 50-50 of the marital share and then he retains the non-marital, and wouldn't there have to be a date? I mean, that's a problem as I see it. Now, maybe that's a problem for the family court judge.
Well, I believe that people can settle to split assets.
They can, but they have to be fully informed, and it seems to me he would have to, there should be some standard law, and I don't have the judgment, so, and I don't know what happened, and I don't want to redo all this. But
Sure.
it seems to me there should be some standard language saying that he's agreeing that the whole thing is marital and waiving whatever, because he's claiming now that he should have been entitled to keep 100% of the premarital and then divide only the post-marital.
Your Honor, the settlement was signed and executed and presumably drafted after my client withdrew. I don't know what was in there, but anything that was or was not in there would not be my client's charge. I don't know all the ins and outs of why and how that settlement agreement executed after my client withdrew, what came to be. But if you look at that agreement on page 19, it says the undersigned parties agree that it is a fair and adequate disposition of the divorce. And it is signed by Mr. Carmichael, who, as the principal of the company, presumably would have the best eye on the value as he saw it of that company at the time, with or without a formal valuation. I believe some of the cases we attached, for whatever it's worth, Your Honor, also have similar issues involving, arguments that a valuation was not performed, but there was a voluntary settlement, which would preclude a malpractice claim, I believe. I attached a few here. All right. Roth v. Cronin, Your Honor, which is attached as Exhibit H, discusses an argument that, a plaintiff felt that she had no choice to settle, that she felt that she was essentially, maybe cheated in the divorce, but the voluntary settlement precludes a malpractice claim. Pinpointed, Your Honor. It's a case I'm familiar with, but I might not have attached that particular one, Your Honor, because
Okay, I'm familiar with a lot
Yep.
of these cases, so it's just, there's some parts of this that are concerning. Regardless. So what about the, even if the divorce stands, okay, even if everything stands, one of his also unhappiness counts, I suppose you can call it, is that she billed for things that she did not do.
Your Honor, we obviously dispute that. We have all the billing invoices. If there, I would agree, Your Honor, this is not the forum to argue against, that the rate was too high or something like that. There are forums for that. I don't think they were. $20,000 is not an excessive amount in a divorce litigation. But that being said, there are forums for that. It is not the basis for a legal malpractice claim, which is what this is. This is negligence, breach, proximate cause.
This is negligent.
Negligence, breach, proximate cause, standard elements, not necessarily on that type of claim.
Okay.
Thank you, Your Honor.
Your Honor, can I speak for just
Yes, briefly.
briefly? Your Honor is correct. It's about a commercial issue. And the billing is, yes, overbilling, and yes, there may be a better form. But when you bill your time that you didn't do, first of all, it's an issue of fact. And actually what he was raising about the emails were issues of fact. But when you bill your time saying that you did this work when someone else did the work, that's not something just for the bar. That's something that's actionable. That's fraud. So there's billing fraud, and the commercial issues are the bigger issues that I hired her for. Her engagement letter is clear. It says not just divorce, it says, but not limited to, in very clear and unambiguous language. She took on a general representation to deal with all issues between the parties.
Well, sir, you have brought a case in malpractice, correct?
No, there's multiple claims in there. There's breach of contract, there's fraud, there are all the rest of them. And there are multiple issues of fact in all of these that have to be determined, which makes this a little too early to have a disposition. Now, the complaint has multiple different causes of action, not just malpractice.
Your Honor, if I may.
You may.
I'm looking through the complaint right now. I don't see anything in the complaint about the valuation being the basis of a negligence claim, for whatever that's worth. We still argue it would be superseded by the voluntary settlement. However, it was not front and center in my briefing.
So I've looked at, I certainly understand your frustration, but everything in here says that you understood the settlement was fair. I didn't need any more time, and I'm going to grant the motion. However, I'm not precluding you from filing any additional claims, but they have to be appropriate under this court, under our jurisdiction. There's some of the claims that you've talked about, the mail fraud, wire fraud, racketeering, money laundering. I don't know that those are private causes of action that can be heard.
Those
by
are
this-
what?
That those are private causes of action that can be heard by this court. So I'm granting this, but without prejudice. Any order, sir?
Thank you, Your Honor.
That's all in this record. What, anybody ready?
We can use Stephon Carter.
Good afternoon, Your Honor. May we approach on this, please?
Yes.
Want to prepare post order for a petition and an FC 206.
The trial.
I believe it was March.
Okay, so do I have the file? Yeah, Irby.
What's the number?
23-573. Are there people related to this file? It looks like on Zoom, so we need to do this on record.
Yeah, hold on, I gotta figure out this.
They're all here, Your Honor.
Okay.
Hold on, Judge.
Yeah.
I gotta figure out who's who.
Yeah.
Yeah,
Okay,
let me know.
okay, and then Schlatter is.
Uh,
Huh?
Dr. Benton. And Thomas, Farsi Manson's clients.
He's not listed, so. Who?
For the
Hospital.
hospital. And I'm Michael Stevenson, I'm for Dr. Thorpe.
Dr. Who?
Thorpe.
THORP.
Yeah. So hold on.
So you would give it to
And the gentleman's from, it's going to be Attorney General's office, co-plaintiff.
Oh, yeah, I can't see his name because he's.
Second row. Please.
Can they hear us? Are we?
Yeah, but I'm not ready.
Okay, just want to make sure. Just let me know when you're ready.
He's good, yeah, Mr. Deliberate.
I think you should. Yeah,
We're gonna give this a shot. So it'll be fun.
Okay. This is docket 23-573 NH, Melissa Patrick, Conservator for Lori LaShawn Irby. Michigan Department of Health and Human Services, intervening plaintiff, and Kenneth Thorpe, MD Associates, Edward W. Sparrow Hospital Association, doing business as Sparrow Hospital, David Benton, and Gratuity, hopefully I said that right, Michigan EMPC jointly and severally. Counsel, your appearances for the record.
Good afternoon, Your Honor. This is Joel Samfield appearing for the plaintiff Melissa Patrick, who's the conservator for LaShawn Irby.
Michael Stevenson on behalf of Dr. Thorpe and Lansing Radiology Associates.
Good afternoon, Judge Amy Schlatter appearing on behalf of Dr. Benton as well as Vituity Michigan PLLC.
Good afternoon, Judge. Matt Thomas on behalf of Sparrow Hospital.
Good afternoon, Your Honor. H. Daniel Beaton Jr., Assistant Attorney General.
I can't hear him.
Michigan
Sorry,
Department of Health and Human Services.
I need you to do that again, counsel.
Slower and louder.
Slower and louder. The court reporter did not hear you. Maybe get closer to the mic.
Good afternoon, Your Honor. H. Daniel Beaton Jr., Assistant Attorney General, appearing on behalf of the Michigan Department of Health and Human Services, Plaintiff Intervenor.
Thank you. Okay, this is a pretrial and we are pending trial in March. And what else are we doing? Are we also doing this? I have a motion to compel production. That's off the table? That's done? Okay. Okay, making sure that was done. All right. So we are ready for trial with Mr. Stevenson. You just handed me a number of records, and I presume that all counsel has this then?
Yes.
Okay. Are there any trial matters we need to address today?
Judge, if I may, and I hate to interrupt, I do want to raise an issue with the court about the trial date, and I apologize, Your Honor. I know there was a trial conflict letter submitted back in October, but Ms. Mattson is scheduled to start a case with her colleague Judge Stokes the week before. We just received our trial schedule in that. It is starting March 3rd, and with the trial schedule we were given, we are going to go over until March, probably March 10th. We expect to finish March 10th. And I apologize that Your Honor wasn't made aware of this. With the court's approval, I was covering this for trial counsel. On this case, I haven't been involved, although I've taken a couple of the depositions involved. But in preparing for this today, I noted that was an issue. My office is working on getting a letter out to Your Honor, and I apologize to counsel that this wasn't raised before. I know the other case fairly well. I actually thought we were going to be able to finish it that first week, but we just got Judge Stokes' trial dates, trial schedule last week. I'm happy to provide Your Honor with additional information if you think it's necessary.
Well, I certainly can talk to my colleague. Let me ask you this. What was scheduled first and which is the older case?
I believe yours was scheduled first. We were supposed to start this case last week in front of Judge Stokes, and it was adjourned to March 3rd. I want to say it was in December, early December. So yours was scheduled first, if I'm looking at the pretrial notice correctly. As far as older case, they're both 23 cases. Yours is 573. Mine appears to be 827. So I'm guessing that you are probably maybe a couple months older.
I'm guessing that probably I trump her because mine is scheduled and y'all can't schedule, you can't move my docket. So I certainly can go down and tell Stokes that that we're moving. Is there any?
And tell Stokes what?
And tell Judge Stokes that she needs to move her trial because she can't just move it and trump my docket. Is there any other reason we need to move this?
No, nothing from plaintiff on that matter, Your Honor.
Are you all ready to go on March 6th on my docket?
March 9th, correct, Judge?
It would be,
I have March 9th.
no, I do jury selection on the 6th. I do jury selection on Fridays, and we pick a jury on Friday and we start on Monday. Occasionally I use Mondays, but not usually.
I apologize, Judge. Thank you very much.
No problem.
What time are we?
Hmm?
I'm sorry, Your Honor. I'm not sure that we had that date. If we did, it passed by me. Is the 6th, what time does the court compel us to be present?
Yeah, we call the jurors about 9 o'clock. We're usually up by 10, or 9:30, 10 o'clock. But so we'll do that, and then we just go right along until we pick a jury. There's only 3 peremptories in civil, as you all know, so it usually doesn't take us all day to pick a jury, and then we will start on Monday unless you really want to start on Friday. I don't have a problem doing that, but most people want the weekend to then get ready for opening and all that. So.
Well, with multiple counsel on the defense end, and they all get their preemptories,
Yeah.
I think we're probably going to need that day as planned. That's my guess.
All right. So, what's the name of the case that Judge Stokes moved on to the 3rd?
It is Geller, Geller, versus Dr. Kavuturu. I'll spell it for you, Judge. It's Kav as in Victor, U, T as in Tom, U, R as in Roger, U. And I can give you the case number, Your Honor, if that helps as well.
Okay. If you have it there, otherwise I can look it up, but what is it?
It's 23-827, or 3 zeros, then 827, NH.
Okay. So what I'm gonna do is tell her that this is gonna trump that, and I'll let you know that that's done for certain, or my law clerk will. So I don't know why, there's no reason we can't go to 6.
Is there, Your Honor, is there, again, for the plaintiff, Joel Sanfield for the plaintiff, is there a scheduling order by the court with respect to motions in limine in this matter?
I don't know that I have the whole file, and of course inherited this, so I don't know, are there motions limiting and other motions that need to be filed?
Nothing's been filed yet, so I anticipate that there may be motions eliminate to be filed.
Okay, so Mr. Stevenson has said yes, so, you can get on my document in February. I don't know what the order says, I just don't have it, like I said, I inherited when, anyways, we had the switcheroo in December, as you all know, and so you all got 2 and 3 judges in your files now, so sorry. None of us are happy with it either, but, whatever it says, I have to get caught up on this too, so it's gonna be, February, between now and trial, so, do you have, does anybody have a scheduling order so that, was there a cutoff? Do we need to extend it?
If I may, this is Amy Slaughter speaking again on behalf of Dr. Benton. We did contact the court. We were told that there was no specific deadline for motions in limine other than they have to be heard before trial and before the week of trial. So that was our understanding. We needed to call and get a hearing date. I was going to coordinate with the other defense attorneys to make, to see if it's possible for us to have them all heard on the same day. And obviously
That
we'll
would be
work with
great.
Mr. Sandfield to see if there's any agreement, and Mr. Beaton to see if there's any agreement on any of the motions to try to pare down and to only file those that really need to be filed.
That would be great. And for trial, do you want the jury to be able to ask questions or not?
I would prefer not, Judge.
Okay, Mr. Stevenson says yes. So my policy is if one attorney wants to ask questions and the others don't, it's whoever wants to ask questions, we go along with that. If you all agree not to ask questions, we don't do it. I have no preference. So, so the jury's gonna be able to ask questions. Anything else that we need to discuss?
What about note taking by the jurors, Your Honor?
I can't hear.
Note, he said, what about note taking by the jurors? Note taking is always allowed. By this court anyway.
Are we number 1 on your docket? I mean, we are going to go.
I can find out, hang on. I would guess so, but I only don't, let me not guess.
Okay.
Let's go off the record for a moment. Okay. So my homework is to deal with Judge Stokes for all of you, and this is the oldest case. So this is going to be number 1, and even if it isn't, if for some reason I'm mistaken, since my staff isn't here, I'm gonna make it number 1. So you're all gonna go, and you'll let me know if you settle. And you're going to bring whatever motions you need to at least 1 week, so they'll be heard at least 1 week before the trial. And then you'll work together to work on, to bring us jury instructions, hard copy and electronic. Anything else we need?
I think we got it.
All right, everybody in agreement, or is there anybody else who's on Zoom needs to make a record or ask me for something? Seeing
Judge.
nothing. Yep, great. Have a great day. I will see you in a few weeks.
Thank you, Judge.
Thank you very
you.
much, Judge, for your
Thank you,
time.
Judge.
You too, thank you. It's all for this record. All right. Who's next?
Oh, Judge, my time is. Sorry about that.
Tyler Brown. Tyler or Tyler Brown? Tap one, there's two of them. There's a Benjamin. One.
Have a great day. This is the original. No. Thank you.
Thank you so much.
Okay. This is docket 22583 FC people of the state of Michigan versus Shamandra. Nope,
Tyler Brown.
sorry, two. You know, I had three, now I have two crowns right after each other. Sorry, I got the wrong one. 253164 FH, people of the state of Michigan versus Tyler Brown. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Barb Luxon on behalf of people of the state of Michigan.
Good afternoon, Brian Jackson on behalf of Mr. Brown, who is not here in the courtroom, and I don't have any representations other than he generally doesn't have a working phone, transportation, or a secure place to live.
Okay. Bench warrant bond forfeiture, however, so when was the last time you heard from him?
There was a pretrial that was in December when I was out of country. My colleague handled that, and I did talk to his uncle, who's a responsible person today, who is going to reach out to him by messenger.
Okay.
But that, you have to log on and see it. And this was a matter of a few hours ago.
Okay, so he wasn't in front of me. I have notes, plus I gave him a PR bond, and it does have notice of today's hearing at 1 p.m. It's now about 2:42, so he's pretty late. But given the circumstance, if you have him here by noon on Friday, well, actually, I'll be probably picking a jury. So if you have him here by 2 o'clock on this Friday, we can proceed with, I guess, a pre-trial. Is that what this should have been? It says bench warrant hearing, but I haven't seen any bench warrant.
I believe there was a, so he was arraigned on the bench warrant back in December.
Oh, so this was just to deal with this bench warrant.
And it was also set for a pre-trial.
Okay, so if he shows up Friday, I may very well dismiss the bench warrant as long as you have a pre-trial. But otherwise, the bench warrant will issue at 2 o'clock.
Thank you.
Fair enough?
Yes.
Thank you. That's all for the record. And it'll be bench warrant bond forfeiture unless he shows up by 2 p.m. Friday. And that will be the 23rd of January. Okay, next matter.
And then we can do Shamandra Brown Walker.
I need that in that file. I just gave you, I need the hearing, sorry, calendar for today.
Is Commander Brown Walker here?
Okay. This is docket 22-583 FC, People of the State of Michigan versus Shamandra Brown-Walker. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Brown Lexington on behalf of the people of the state of Michigan.
And is anyone here representing Ms. Brown-Walker, or is she here? Does not look like it, so bench warrant bond forfeiture. This was scheduled for 1 o'clock and it's now 2:44. She is seriously late, so I have no reason to believe she's here. There's not been a phone call. She's not on Zoom in the hallway or the courtroom. It's failure to appear for pretrial. Okay, next.
Nope.
Okay, next. Do we have anyone else?
I believe that's it for our docket.
Okay, so all the other,
Everything else should have a date at this point.
okay. And what about the motion for default judgment? So, oh, wait, someone's here on that, all right. This is.
Wait, which case is that?
One in the bottom of page 7. Hallie Lycos, Leah and Hallie Lycos.
Yes, we are here.
All right, let me
Wait,
read the final. We're not.
Lycos, you said?
Yeah. Bottom of page 7 for the afternoon.
Okay, so.
See you tomorrow. All right. You ready? All right, this is docket 25-3597 and O. Hallie Lycos versus Scott Totten and Maureen Totten. Counsel, your appearances for the record.
Good morning, Your Honor. Adam Smith appearing on behalf of Haley Lycos, and my client is also on the Zoom.
All right, thank you. And are you here for, are you defendant?
Yes, ma'am.
Come on up to the podium. And are you Scott and Maureen?
Yes.
Yes. All right, please raise your right hands. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
Absolutely, yes.
All right, and you are Maureen Totten?
Yes.
And you are Scott Totten?
Yes.
All right, you may both have a seat. And this is a motion for entry of default judgment against defendants, and this is filed by plaintiff. Counsel, you may proceed.
Yes, Your Honor. So this action was filed last July 8th. The defendants were both served by personal service on September 20th, 2025. The defendants never responded to that complaint, so default was entered on December 5th, 2025, which was then served on the defendants. They didn't respond to that either. They didn't respond to this motion, and so here we are today. I'd like to move for default judgment against them and ask my client some voir dire questions regarding damages.
All right, before you do that, let me see what's going on here. So you received by personal service notice of this claim,
Yes, ma'am.
and then did you?
I did respond. I can get copies of it from downstairs. I just didn't. A copy didn't get sent to him.
Okay,
for some reason.
when did you respond?
I'm not sure which one it was. It was within that period that I was supposed to have done.
Okay.
And I've got copies, but I didn't get them yet. I mean,
Okay,
I'm almost, I don't have anywhere to put my papers.
okay, hang on. So, sir, have you seen this, documentation?
No, I have not seen any. I have not seen anything
Okay.
from the defendants.
So I think we all need to take a look at this. I didn't know they had a response either, and Blackhawk didn't pull it, and so if they have filed a response, he's not represented by counsel, they're homeless, and he says he filed it timely. Can we move this a couple of weeks so we all can take a look at it and
I'm
see?
sure it's
Yeah, that's okay.
I mean, the problem is if I rule today, I don't know how I would rule, but nonetheless, it's not the date for the hearing. We're gonna end up in a lot of he said, she said, and all of this. And if we need to go to trial or we need to go to mediation or whatever, we ought to go through the process if they in fact responded. I suspect what they've done is some kind of letter rather than a legal sort of format, but the court does accept that as a response as long as they've done it timely. If they didn't do it timely and they're homeless and there's other extenuating circumstances, that may be enough to move this court to waive the untimeliness and proceed regardless. So rather than shooting in the dark, I would like to set this out a couple of weeks if you don't mind. Sorry for the inconvenience, counsel.
Okay.
So may I have my law clerk email you a copy, and we'll also get a copy?
Sure.
So do you have your schedule there? So this is the 21st. How much time would you like to review this? A week, 2 weeks?
Depends how quick we get it. Yeah, a couple weeks.
So would you like it the 4th or the 11th of February or the 18th?
4th, maybe.
4th?
Yeah.
All right. Can you be back the 4th of February at 2 o'clock?
Yes, ma'am.
All right, so before you leave, we're gonna get you a copy of do you have copies of all the paperwork?
They're downstairs, I can get them from the.
I don't mean from the clerk. I mean, do you personally have a copy?
No,
Okay, before you leave, we are going to make sure that my law clerk's gonna print you a copy of what you all filed, what they filed, and then we're gonna get that to the plaintiffs as well, so that we can have a meaningful hearing. You may want to contact the state bar or legal aid so that you're represented.
okay.
Okay, so it might just be easier for you. And you certainly, if you're homeless or near homelessness, whatever, you certainly qualify for it. You just have to contact them, okay?
Yes.
And then we will schedule this for February, what did they say, 11th? Did they say 11th?
They said
4th. Okay, so I'm
4th.
sorry, February 4th at 2 p.m. And it'll be a continued motion for default. Or I guess early summary disposition, is that what you want to do?
I would like to move for default since they were in default unless the court shows otherwise, so.
All right, so here's the thing, if they show otherwise, if they filed it timely, then we'll have a scheduling conference, okay? And you could also use that time depending, I don't know what's been filed for an early motion for summary, I really don't know. None of us have
Okay.
seen it, so let's take it as it comes, but I'm reserving that time for you. If you don't want to use it, then please let me know so I can schedule something else, and then we'll move it into an appropriate slot for whatever it is that gets filed, okay?
Okay, thank you.
Okay, so see you all February 4th at 2 p.m. Now, sir, how do we reach the two of you? Do you have a mailing address?
Yeah, I got a mailing address.
What's the mailing address?
539 Samantha Avenue.
And is that Lansing?
Yeah, Lansing, Michigan, 48910.
And is that, that's a mailing address, do you stay there? What is that?
That's just where a friend of mine stays.
Okay,
My ex-fiance, I guess you could say.
okay. And she's okay giving you the mail?
Yes, ma'am.
Okay, so, did you get that address, sir?
Was
539
that-
Samantha Avenue?
Okay, yep, that's what I had down.
Okay, so we will be using that as your mailing address. Keep all your addresses current, both of you, okay?
That's where everything has been mailed to this.
So we're gonna get you copies, so please stay here a moment, and then, sir, we're gonna get you what you need, and you can just give that to your client then, okay? Thank you.
Okay, thank you.
That's all for the record.
Does he need copies of?
He needs copies of whatever they filed in their answer, which is probably downstairs.
Okay.
Or you pull it off the computer.
And then he needs
They need copies of everything.
okay, and then he needs
He needs a copy of what they filed in answers, so that we can see if the default's viable.
Okay, check Raj.
Okay. Okay. Now, do we have docket, are you ready on the next one, Nancy? This is Katerine Oliveira.
Oh, yes. Hold on, I gotta break these down too.
Yeah, you just hang back there. I'll get it here in a second. Sorry. Yes. Yeah.
Let me know when you're ready. I'll ask you more questions.
Okay, I think I'm ready.
Okay, this is docket 24540 CD. 24587 CD. 24584 CD. 24177 CD. Counsel, your appearances for the record.
Paul Hebner on behalf of the plaintiffs, Katerina Oliveira, Ms. McKissick, and Ms. Kira Berry.
Your Honor, Bradley Gray on behalf of defendant Maynard Costaricin, Christine Latshaw, and Edward Williams.
Good afternoon, Your Honor. Zachary Jugan for defendant Joseph Zuziak.
Okay, so what are we doing here today? I think this is the case my law clerk said, I signed under the 7-day, but they had not made me aware of you moving in a week, so probably shouldn't have signed because there were objections, is that right?
Your Honor, if I may, we did file an order during the 7-day period. Beyond that, I'm not entirely sure what we're doing here. MCR 2602B3 states objection to pro quo.
No,
You gotta slow down a minute, the court reporter, where does he?
MCR.
MCR.
2602B3 states that an objection to a proposed order must state with specificity the inaccuracy or omission in the proposed order. Plaintiff's counsel did file an objection as well as a proposed alternative order. However, it doesn't state at all what the inaccuracy or omission in our proposed order was. Additionally, it did not contain a notice of hearing that is also required under MCR 2602B3C. Beyond that, our contention is that the proposed order that we submitted mirrors the directive that the court gave, that plaintiff either turn the messages in question over to us or turn them over to the court. Further, the remedy we state in our proposed order is
Say that
being
sentence
remedy.
again.
I'm
Just a
sorry?
minute,
So
Go back.
something remedy, I don't know.
the sentence that you said,
The last sentence, it's
the last sentence you said, she skipped.
Oh, I said that our contention is the proposed order mirrors the directive that the court gave at the hearing in November, and that the remedy we state in our proposed order is the routine and standard mechanism for when there's a question of whether documents are truly privileged. Nothing in our order was outside of the directive from the bench or any of the requested ordinary practice in situations like this. So we're asking the court to enter our order as it accurately reflects the discussion in November's hearing, and no objection was filed properly under the procedures.
So,
Response?
yes, Your Honor. So the order that was submitted by defense counsel is overly broad. The discussion that was had on the record concerned the Facebook direct messages from plaintiff Katerina Oliveira and plaintiff Aurora McKissick, and the text messages to and from Katerina Oliveira and plaintiff Kiara Berry. The order that defense counsel submitted was never sent to plaintiff's counsel for review prior to submission. It has a blanket grant to produce the
It has a
requested
what?
supplemental discovery.
Hold on, it has a what?
The statement that the plaintiff will produce the requested supplemental discovery responses and or documents directly to defendant's counsel. The discussion that was had and what the court ordered was concerning these specific instances where two co-plaintiffs were messaging each other on Facebook, and in another instance, they were messaging each other via text. As far as the objection and order that was submitted by the plaintiff, the order itself is much more specific and contains exactly what was discussed on the record back in November of 25. I'm not sure why there wasn't a notice of hearing, but
I frankly, Your Honor, I don't have any explanation for that, but we are here at a hearing for it, so I'm not exactly sure how that happened. But in any event, the substance of the two orders seems fairly close, but in a case involving an invasion of privacy and issues involving electronic messaging and electronically stored data, I think it's important to be specific. And that's what the order reflects.
What data?
Electronics for data.
What was it?
You said electronics for data, correct?
Electronically stored data, I think being specific.
Electronically stored data.
Okay.
So let me ask you both, or all. Do you want an order that is more specific? You all know what it meant. I don't know that you, and clearly you're all here, so somehow you got notice. So really the notice is waived by court rule. You're here. I guess you could have called to reschedule. You didn't. If you need more time, or if you all want to get together and look at the order and agree on it, I think the one I signed is fine. But is there some language you would specifically change, or that doesn't give proper notice of what the order was?
So the language that's contained in plaintiff's order.
No, start over.
Okay, you gotta talk slower and stay near the mic. My court reporter has to pick this up, so it's just a little difficult. I don't know if it's the weather or what, but we're having a little bit of trouble.
So really the only material change is that the order should state what the defendants were requesting, which is these Facebook direct messages to and from co-plaintiffs and text messages to and from co-plaintiffs. The order as stated by the defendants is for the broad supplemental discovery responses, which isn't what was discussed on the record. That wasn't what the court ordered, my understanding.
Your Honor, if I may, those messages that are in plaintiff's proposed order are exactly the messages that were discussed and which were requested to be supplemented in a deficiency letter, as well as our motion to compel. Further, plaintiff's order does not request for the court to perform an in-camera review, which was something that was discussed during the hearing in November as well.
It seems to me a little language tweak. I mean, I've signed this already, but it's really the court's, we didn't receive, or whatever. I don't have a problem making it more specific. Do all of you have a problem making it more specific?
No, I don't.
Great, why don't we just do that and just get rid of this issue? So it's not even worth the time. I think we have smart lawyers who can figure it out. If you want me to sign it so it's cleaner, I'm happy to do that. Just submit it, I'll sign it. Maybe you could stipulate to it so we don't waste any more time, because the only thing that really pisses me off about this is that it wastes time. And we're all under a scheduling order and we've got to get these cases heard. So let's be smart about it. stipulate to the language, if you can't get me on the phone, I get the transcript from my court reporter, she'll read it back, and we'll do it that way. Can we do that?
Your Honor, just to clarify though, so that we don't end up before you again over this, I just want to clarify the in-camera review portion.
The in-camera review portion was that if you get it, I think what it said, what it was meant, if you get it, you think that it's something that shouldn't be out there, that's protected, I will review it first. Otherwise, there's no real reason, is there?
Correct.
Should it say anything else? I mean, I think that was it. That was the gist of what I wrote back in November. And if you want me to review it in camera regardless, I'm also happy to do that.
Your Honor, it would be defendant's Maynard's preference that it be reviewed in camera.
I'm happy to do that, and then we can have a hearing after that if you want.
Okay.
Great. Come up with an order, stipulate, I'll sign.
Good. Thank you, Your Honor.
Thank you. It's all for the record.
Now we just have weapons court.
Yes.
Thank God, yeah. We've worked in this now. I hate passion for that reason, because it's not clear. And I don't think it does there any justice. I just want the chief judge has to approve what we do. Just a few years ago. Too far.
I never had a problem doing these numbers and.
So the fastest I wrote today was what? How many words a minute? Times that by 3 and add another 22. 322 a minute.
And Nancy, do you know if we got any fresh batteries?
I don't know, are they?
These are dead.
Okay, I'll go look.
Thanks.
I might go back and listen to the recording and then rewind. Let's do it right.
Just the pretrial.
Yeah. Right.